Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Sameer Malkani. He is going to speak on administration of justice. He is from Subhash Desai College of Law. So without wasting further time, I would request him to commence with the lecture. Thank you.
Hello everyone, my name is Sameer Malkani. I am from Subhash Desai College of Law. We will be discussing the topic today, which is administration of justice. Uh, Administration of justice is a very wide scope. It generally deals with how the justice is being administered in the country. So overall, there are three legs of the constitution. One is legislative leg, one is executive leg, and third is judiciary. Now the legislative leg deals with making of law, which is legislation. They do not administer justice. The executive leg deals with how to implement the laws, and the third one is judiciary. Judiciary deals with how the administration happens, and they are the only ones who have the authority to do so. So we'll be discussing a few things step by step in a very simple way. So administration of justice, it refers to a system and process where the laws are enforced upon and disputes are resolved and fairness and equity and social order is upheld. So unless and until there is justice, social order cannot be achieved, and there will be chaos. To ensure that there is a social order, law needs to be enforced, and rule of law will supersede everything else. So no matter if you are an individual or if you are a government authority, the rule of law will be applicable to all. So in administration of justice, there is a very basic concept of Article 14, which ensures equal protection of laws and equality before law. So these two concepts are taken from two different countries. Equality before law is taken from UK, which is United Kingdom, which means everyone is equal before the law, and the concept of equal protection of law is taken from United States, wherein in USA every state has its own legislation, and they have given rights to the federal authority. So they have ensured that everyone is protected equally. So that is how it is. So in Article 14, there are two things: equality before law and equal protection of laws. Now we'll go to the next part, which is how the administration of justice happens, occurs, and what is the constitution behind it. Now we'll start with the apex court, which is the Supreme Court, which is formed under Article 124, and any law, any judgments passed by the Supreme Court, they are enforceable on everyone, including the lower courts and all the government bodies, as per Article 141. So any judgment passed by the Supreme Court, everyone has to follow, and this article clearly states that. Apart from that, when we come to the lower courts, then there is High Court. Now any judgments which are passed by the high courts, they will be applicable throughout the state, which includes the state governments. So the High Court is the highest judicial authority for the state, and the Supreme Court is the highest judicial authority for the country. So any judgments passed by the High Court will be applicable throughout that state. Now there is also one exception, that High Court can also pass judgments which might be applicable outside, if the cause of action is within the state and it falls within the jurisdiction of the High Court. So I'll just specify that specifically. The jurisdiction of High Court will extend over any person or authority, including the government within the territorial limits of the state or the states under the High Court's jurisdiction. So High Court can order writs under Article 226, and High Court has the supervisory role under Article 227. Now under 226, they can issue writs of mandamus, habeas corpus, certiorari, or writ of quo warranto, or a writ of prohibition. So these are 5 writs that generally can be issued by the High Court under Article 226. Now, apart from that, the city civil courts and the lower courts, they are forming within the they are formed by the state governments under the Article 233. So high courts do not fall within the state governments, they are above the state governments, and the lower courts are formed within the constitution of the state government. So every state government can form the respective city civil courts and the lower courts. Now, what is the origin and the concept of equal protection law, equality before law and equal protection of laws? So we have already discussed that equality before law is based on a UK concept, and equal protection law is a US concept. Now there is a detailed explanation. There are different case laws that that can be discussed in this particular case. So the principle imposes a positive obligation on a state not only to refrain from arbitrary or discriminatory laws, but also actively protect individual rights. This is for equal protection of law. It permits the state to make a reasonable classification to address special needs such as reservation for scheduled caste, scheduled tribes, other backward classes, which also includes women and children, which generally falls within the ambit of Article 15. That a special acts can be passed under special provision to ensure that everyone is getting equal protection of law. Now, Supreme Court of India has also clarified that equal protection law is about about treating like cases alike and unlike cases differently. It is justifiable and proportionally it is enabling social justice. So there is a case which happened, which is Bombay Prohibition Act, which was passed in 1949, which was challenged. But before I go into that, there is a general classification that I would like to discuss. So the difference between equality before law and equal protection of law. Now it's a British common law as far as equality before law is concerned, and equal protection of law is of US Constitution, which happened in 14th Amendment, and the concept is formal, no one is above the law, and equal protection laws is substantial equality. It is reasonable classification is allowed under this, and the nature is it restricts arbitrary state privileges, and in equal protection law it requires the state action to prevent discrimination. So this is a positive concept, and the other one is a negative concept. And then the scope is uniform application of law to all individuals, and here in equal protection of law it is differential treatment allowed to promote fairness and equality both. And it prohibits equality before law will prohibit special privileges and arbitrary exclusions, and equal protection of law enables affirmative action and protects minority and weaker sections, which is widely the case in India. Ministers and ordinary citizens are equally liable under equality before law, and reservation in government jobs and backward classes are allowed when it comes to equal protection of laws. So what is the objective of administration of justice? Is to ensure that uniform application of law with no discrimination by any authority, and maintain social order, protect fundamental freedoms, and uphold democracy through just and legal process. Now let it be a civil or a criminal matter, in both cases this is followed. Now there are certain landmark cases. One was Manika Gandhi versus Union of India. It highlighted that fairness and equality are dynamic and evolving concepts. So it is not a rigid thing, and it is an evolving concept which is essential to justice. Now we'll come to the discussion of one of the cases wherein equality of law was upheld. So there was a case of State of Bombay and another versus FN Balsara, wherein the state had passed a law of Bombay Prohibition Act. So what happened in this case was an act was passed wherein manufacturing of liquor was prohibited in certain states. Now this was in the year 1949. So during that time, Maharashtra and Gujarat, they were the same state, because Maharashtra and Gujarat were formed in 1960. So that time both the provinces were falling in the same state, which is Bombay province. So the court applied the old doctrine of equality in this particular case, which means formal equality, where the law must apply equally to everyone without arbitrary discrimination. So this doctrine upholds that all individuals are equally subject to the law without any special privileges or exceptions, ensuring equality before law. However, the court recognized the formal equality is limited to procedural equality and does not extend to addressing the underlying social and economic inequalities. So finally, what happened that some part of the law were struck down, but overall the law was kept, and it was kept intact to certain extent, but whatever were parts which were violating the fundamental rights, they were struck down. And whenever such thing happens, it is in line in consonance with Article 13 of Constitution of India, because if any law is passed which is which is in contravention to part 3 of the Constitution of India, which is the fundamental rights, it automatically is void. We'll go to the next case. So I'll try to keep it brief. This was the new doctrine of dynamic equality. So here this was a case of E.P. Royappa versus state of Tamil Nadu. So in this case, Mr. E.P. Royappa was a senior IAS officer in Tamil Nadu. He was initially appointed as a chief secretary, and then later on he was transferred to a lower post, for which he had approached the relevant court. So the court held that the transfer of Royappa was arbitrary and violated Article 14. Although the court could not conclusively prove there was a malified intent in doing so. So the judgment marked a departure from the narrow formalistic interpretation of Article 14. It established the principle of arbitrariness, and arbitrariness is the antithesis of equality, and explicitly stated that Article 14 strikes down all forms of arbitrariness by the state. So if any state is taking any action which is arbitrary and it is in contravention to part 3 of the Constitution, by way of this judgment, it automatically gets struck down. And then we'll come to Article 15.3, which in a way we also try to understand in Article 14 under the part of equal protection of law, wherein Article 15.3 specifically allows the state to make special provisions for women and children. This means Constitution will permit the state to enact. Now when we say state, it can be a state government or it can be the central government as well. So it will permit the state to enact the laws and treat women and children differently for their protection and welfare without violating right to equality. These special laws are a form of reasonable classification justified by their unique needs. For example, Child Labor Prohibition and Regulation Act of 1986. It protects children below 14 from hazardous employment. Similarly, there are cases of Maternity Benefit Act 1961, which was there. Now it has been included in the 2020 Code of Security bill, which was passed in 20th September 2020. And the law, now simple explanation behind this is the law may treat different people differently only when there is a clear sensible reason to group them separately. So when there is a clear and sensible reason to group them separately, this is one criteria. Second is this grouping helps the law's intended goal. So this clarifies there is no arbitrariness whenever a law is being passed. Now special laws for women and children are allowed because they acknowledge different needs and aim to protect them, which is fair and reasonable, and it is not discriminatory to others. So thus reasonable classification under Article 14 and the provisions under Article 15, they go hand in hand, and together they ensure laws can fairly treat people differently when justified, and promoting equality in a meaningful and a practical way. Again, the right of article right under article 14 is justiciable. Violations can be addressed through courts, including the Supreme Court. So let's say if there's a violation of fundamental articles, fundamental rights. If you go to a Supreme Court, it will be under Article 32. If you go to a High Court, it will be under Article 226. Now, Article 14 is not absolute. It is subject to certain reasonable restrictions and can be suspended during emergencies as specified in the Constitution. The simple logic behind that is, if there is no state, there cannot be fundamental rights. So, if there is any kind of threat to the nation, then all the rights that we have, they may be suspended till the time the threat is averted. So that would be all, and I hope it was an informative session. Let's hope to meet again in the future. Thank you.
Sameer, thank you very much. You had spoken on a very important topic, because the topic which you had selected, administration of justice, it's a very vast topic, and you have nicely covered that particular topic in the particular lecture.
Thank you.
A small token from Hammurabi to you.
Thank you, sir.